Well, major efforts to end all forms of discrimination in the United States have been underway since the 1960s. Now, there were some individual accomplishments that took place before that, some advancements, but it's pretty well been policy for about the last 50 years or so. Still, there are lots of arguments about what has been done and what some see as still what needs to be done. And on this one, the law is by no means settled. What's been called distributive justice just does not provide clear-cut solutions. The main action to combat discrimination in this country took place nearly a half-century ago. It was back then that Congress passed what has now been called Title VII of the United States Civil Rights Act of 1964. The main step forward was the creation of prohibited classes of discrimination. And since then, anti-harassment training has become a major part of entry-level training entering even the smallest of workforces now. Certainly it's true in the major workforces, large companies, and it's now filtering down through medium-sized companies and even in small companies as employers strive to protect themselves from the legal problems of discrimination. Here in the United States, we have what's called the Equal Employment Opportunities Commission. Now, this is an agency that ensures that employers do take steps to prevent discrimination and harassment on the job. The agency provides guidelines and resources to detail the appropriate behavior and to even offer direction and parameters for both employers and employees. Now, the law pretty much deals with issues of race, gender, age, national origin, disability, and color. Most other issues are pretty well left up to the employer. So you can imagine that's led to the arguments from those who feel that the employers now have too much control, while business operators are still complaining of too many regulations. So the problem grows when the issues reach the world stage, because there are different standards in different countries. As Paul Harvey used to say, it's not one world. Even in the U.S., there are still claims that we have what is called a stealth discrimination. Now, there are reports and studies that show even ethnic-sounding names can be subject to avoidance during the hiring process. Gender discrimination has been emerging as perhaps the most controversial form of discrimination. Women will say that they face different challenges than men in seeking employment and promotion on the job. Now, many may claim, women do anyway, that they have to be bullies on the job in order to be taken seriously, where for a man that would just mean, hey, it's just a guy doing what it takes to get ahead. But then again, whether it's male or female, somebody acting like a bully still has to worry about ruining his or her own productivity, because if other people aren't going to work with them, the job isn't going to be done very well. So through it all, the American workforce is now considered to be its most diverse ever. And that can bring up some other difficulties, though. Different genders and different racial and ethnic groups may have different value systems, and that could threaten tension in the workplace. Stereotypes may even become more pronounced in the differences in how groups differ and view each other. An area where these problems arise is what we call multiculturalism. Now, it can be difficult to understand the differences between groups. For years here in America, we've just had a way of doing things, and we've all pretty well understood it. Now, though, it's necessary as we get more immigration into the country and we do start reaching out to operations in other parts of the world, that we start having to deal with other people and the way they are used to dealing with things. And that's a lot of times very different than what we've seen in this country. And it can manifest itself even in how good a fit someone might be in an organization, and then some mistakes could actually lead to racial discrimination lawsuits. A next step in righting the problems of past discrimination is a process called affirmative action. And there have been questions and disputes over how to balance employee rights to fair treatment with competing employee rights. An advantage set aside for one employee of an aggrieved class can actually be seen as discrimination against someone else. Decisions to try to increase the racial representation of one class, first of all, to balance the workforce, well, that may actually be seen as reverse discrimination by someone else. And the arguments regarding affirmative action go both ways. There are those who say that minority and women would have never gotten to the same level of accomplishment and getting into jobs and the salaries that they've been able to achieve without affirmative action, at least not to the extent that we've seen it so far. On the other hand, there's the argument made that affirmative action is discriminatory in its own right and actually works against minorities. And there are minorities themselves who are making this claim. Through affirmative action, minorities can be seen as incompetent, incapable of ever having had the proper equipment or the training or the attributes to take on even a job itself, much less the management positions or the salaries that go along with it, if it hadn't been for someone in the law saying that these people had to be hired. Well, that can make for a difficult situation in hiring someone who could be seen as a best fit for a particular position. So in the workforce, there are some legal requirements to deal with. For firms with more than 50 employees that have government contracts, there is what is called Executive Order 11246. That basically requires that affirmative action efforts be taken to ensure equal opportunity. And in cases where 11246 does not apply, well, the courts can require actions to address past discrimination. It's of course looked upon most favorably when a firm does take it upon itself to use the guidelines to work out any of those inequities on its own. Affirmative action, however, does not mean that the system can run roughshod over those in the non-protected groups. Affirmative action, for instance, may not, unnecessarily infringe on the majority rights in hiring or advancement. Now, it may not set aside positions for minorities or protected class members. There can be no exceptions and expectation of employees, and it should only be temporary to simply accomplish a mission to achieve a balance, and there should only be minimal intrusion into the legitimate, settled expectations of other employees. So these issues are going to be with us for a long, long time.